Good afternoon, everyone, and my apologies for being unable to come up to Sydney. I've just returned from an arbitration overseas and caught one of those wogs. But I'm very grateful for the opportunity to say a few words about the wonderful new book. And I'd like to congratulate Vivienne and Luke on editing an excellent publication. The work deals with foreign direct investment, and it's very broad in scope. It deals with both the laws and policy underlying foreign direct investment in Asia, and it also deals with dispute resolution, so the compass is broad. The editors have succeeded in bringing together an outstanding group of contributors, and I was running through the various countries that the contributors have expertise of, and I've jotted them down, it includes Japan, China, Vietnam, Hong Kong, Malaysia, India, Indonesia and Singapore. And a number of the contributors are old friends of mine and are very, very experienced and outstanding people. So all in all, I think the book brings together an excellent group of contributors. As the authors remind us, or as the editors I should say, remind us in the preface, foreign direct investment are influenced not only by legal traditions, and of course Asia is very diverse in its legal traditions, but also by policy and cultural traditions and indeed economic factors. From Australia's perspective, we recognise the importance of our engagement in Asia. Certainly our trade and increasingly our investment is targeted to the Asian continent. So too is Asia of growing importance to an inward investment in Australia, and we see this on a regular basis, influenced not only by legal considerations in this country, but also sometimes by xenophobic factors. It is apparent to me that our hosts, Alan's Arthur Robinson, are actively involved in international investment in Asia, and looking up their website, I was very impressed to see the extent of the firm's offices throughout the region, in Bangkok, Beijing, Hanoi, Ho Chi Minh City, the list goes on. From my own personal perspective, I taught international trade and investment many years ago. I've not kept up with many of the more detailed developments, but I have in one aspect an ongoing interest in international trade and investment, and that is through my work as an arbitrator. I sit both as a commercial arbitrator and as an arbitrator in investment disputes. And I'd like to briefly say a few words about dispute resolution in investment disputes, because that's the area in which I claim some current knowledge and perhaps a little expertise. We've witnessed the establishment of international arbitration for investor-state disputes. It's called by some arbitration without privity, because it's arbitration without an arbitration agreement in a contract between the investor and the host state, and rather arbitration rests on rights to institute arbitration under a bilateral investment treaty, a free trade agreement and certain multilateral agreements. These treaties provide certain minimum standards for investor protection and confer on investors a right to institute arbitration under the ICSID, the ICSID Additional Facility and UNCITRAL rules. investor-state arbitration has grown remarkably quickly. If we go back 2 decades or 2.5 decades, there were hardly any arbitrations in this field, but now they're booming, and we see how significant ICSID has become as the main body which is involved in the administration of these arbitrations. Like any relatively new system, it's not free from controversy. Let me list some of the criticisms or reservations made in relation to the investor-state arbitration system. Some say that there's an alleged bias in favour of claimants, that is investors, against the states, particularly on the part of commercial arbitrators. Indeed, some states, such as Bolivia and Ecuador, have recently denounced the ICSID Convention. Some people argue that public policy considerations are not adequately considered by arbitral tribunals. It can be argued that bilateral investment treaties give foreign investors protection which local investors do not have. And this has led Australia to recently announce that it will not hitherto conclude new bilateral investment treaties. One might think that this places Australian companies at a disadvantage when they wish to invest offshore. But of course, an Australian investor can incorporate in a third country which has a BIT with the host country. Another criticism of BIT investments, rather arbitrations, is that there are too many commercial arbitrators involved in them. On the other hand, it's important to have regard to some factors which mitigate the other way and give some balance to investor-state arbitration. Investor-state arbitrations have resulted in a rich body of jurisprudence and case law, and there has developed a system which is not unlike the common law system. In commercial arbitrations, the awards are usually confidential, but in many investor-state arbitrations, the awards are published. And so tribunals will read previous awards and will carefully analyse the reasons of previous tribunals, either following their reasoning or distinguishing what they say. The criticism that commercial arbitrators favour claimants is more than balanced, in my view, by a number of arbitrators who have a public international law background and who are thought to nearly always side with the state, which is the respondent in arbitrations. So if there is a bias, it works both ways. Some might be thought to be inclined towards the claimants. Other arbitrators seem to have a heavy bias towards states. Of course, bilateral investment treaties have done just what they were intended to do. They have given investors confidence to invest in third countries, and as such they constitute an important tool in the risk management of an offshore investment. What of the future? Well, the balance between the rights conferred on investors by bilateral investment treaties and the public policy interests of the state is still to be developed, and jurisprudence is and will continue to evolve. And everyone is looking very closely at the impending litigation and arbitration between Australia and the tobacco companies. Here we have the public policy considerations which will no doubt play an important role. There's no doubt, in my view, that a state such as Australia could ban smoking on the basis of its health concerns. But can a state restrict the use of trademarks or prohibit the use of trademarks and pass legislation which specifies the packaging on cigarettes? Public policy comes into this. There's a public policy in ensuring the health of the people in a state. And there are also commercial considerations asserted by the claimant. There are important questions in international investor-state arbitration which still remain to be fully resolved. One is whether a state can in effect exclude investor-state arbitration under ICSID or UNCITRAL by inserting an exclusive forum agreement in a contract between itself and the investor. That forum may provide for disputes to be referred to the local courts exclusively. And there have been a number of decisions going either way on that point. In Asia, the number of investor-state arbitrations has been relatively modest, and statistics are provided in the book. That's not a matter of concern to me at all. I remember 10 or 15 years ago speaking to people in Europe who observed that commercial arbitration would never take foot in Asia. There were very few commercial arbitrations in Asia a decade or two ago, and look how that's changed. Exactly the same will happen with investor-state arbitrations. As Asia continues to grow and develop, arbitrations will follow. Recently, an ISA was instituted against China, and I predict in the future that China will in fact have a role not as respondent but as claimant in investor-state arbitrations. As I understand it, China is investing heavily in many countries, including Africa, and China's policy is to ensure that there's a BIT between China and the host state. So in the future, let's see if China is in fact a claimant. Cross-border investment underpins the system of international trade and globalisation. It is vital that we fully understand it. Foreign Investment and Dispute Resolution Law and Practice in Asia is an excellent book. It has a wide compass. It is written by people who have a deep and intense knowledge of the countries of the region. As such, it fulfills an important niche and will prove a valuable addition to literature on the subject. I've said that the book is written by experts from many countries. It is also replete with statistics and tables. It really is a wealth of information. I warmly congratulate the editors and contributors on an outstanding publication. Thank you very much.